You're listening to Rethinking Trade with Lori Wallach.
Small business owners and farmers are protesting the Korean WTO and NAFTA are transnational forms of autocratic governance that subordinate our
North American free trade agreement.
Seattle has never seen anything like it.
Mexican workers face threats of violence.
Trade policy has delivered one punch in the gut after another.
Welcome back to Rethinking Trade, where we don't just talk about trade policy, we fight to change it. Today's episode is actually a pre-recorded live event that we held on May 27th. It was called The Fight for Workers' Rights in North America, a discussion of major recent developments in the fight for workers' rights under the revised NAFTA. The event was hosted by Lori and featured a panel of really excellent guests whom she will now introduce. Enjoy the episode and stay tuned for more in the future.
Welcome to everyone, panelists, activists, journalists, policymakers. Thank you for joining us today. This is a webinar to give updates on some very exciting developments with respect to the revised NAFTA and the fight for workers' rights in North America. We have some of the leading lawyers from Mexico and the US who are trying to use the new revised NAFTA, the US-Mexico-Canada Agreement, the USMCA's labor rights tools to try and improve what have been decades of terrible race to the bottom conditions with protection unions in Mexico colluding with bosses, keeping wages low, so that almost 30 years into NAFTA, Mexican workers' wages in manufacturing are actually lower than Chinese workers' wages in manufacturing. This is an untenable situation. It is a fundamental human rights issue. And the new NAFTA, the revised NAFTA, is designed to try and take on some of those issues. And you're going to hear from some of the people who are trying to make it work. We are also going to be today releasing a new public citizen report that dug into the Mexican government data with respect to the implementation of the new labor court and institutional justice system that is both an obligation of Mexico's labor law reforms that flow out of Mexico's constitutional reforms for labor rights, and that are also obligations of the revised NAFTA. Those new institutions are to replace what have been captured institutions that have helped, if not facilitate, certainly tolerate protection unions and a system of labor unions that do not represent the interests of workers, but rather the bosses. So the new institutions are obviously a key part of the story of improving working conditions, wages around North America. So just once again, in case you came in late, we are very honored to have Susana Prieto with us. She will be speaking in Spanish. If you need interpretation from Spanish to English, please see the buttons in your Zoom near the Q&A at the bottom. It says interpretation. There will be live Spanish to English interpretation there. You can switch languages if that is useful for you. And obviously, if you have questions that you want to ask to Susana in Spanish, that will be interpreted as well. There will not be interpretation the other way around. So this will be Spanish to English. Use the interpretation button on the bottom, please. So many people in all three North American countries fought very hard to document the damage of the old NAFTA and that model of race to the bottom working standards, but also to try and fight to have a different kind of agreement. And there are some novel institutions, not the least of which is the rapid response mechanism that was set up to be able to have enforcement of labor standards vis-a-vis individual companies in a faster and more direct way. And we're going to hear today about two of those first cases that are in the rapid response mechanism. And we're going to hear about two cases that are labor standards cases that are state to state. The case that is the first case, which is about Tridonex, we are going to have the pleasure amongst our lawyers of hearing from Ben Davis. Ben Davis is the international director of the United Steelworkers Union. He previously has worked at the Solidarity Center and was the Mexico officer for the Solidarity Center. He is one of labor's leading experts about labor rights in Mexico, and he is a leader in preparing the case about Tridenex, which is a facility that Susana Prieto and SNITIS, the independent union she has helped create, has been trying to organize an independent union for. This case, Ben will speak about first, and then we're going to hear about the state-state cases and about the report. So it's my honor to introduce Ben Davis. Ben, please.
Hey, thank you very much, Lori. Thanks, everybody, especially Susana for being with us, because I know she's in the middle of some very interesting activities right now. And Danielle, for all your work on the report, and everybody here. I think the Tridenex case, which was filed under the rapid response mechanism, was filed with the U.S. Trade Representative, and they're now in a 30-day period of internal consultation, which ends on June 9th, and then they'll make a decision about whether to go forward with the case and engage in formal consultation with the Mexican labor authorities. The case really comes out of, I won't tell you all the history because this is Susana's history. I don't want to be telling her story to you, but it comes out of a massive uprising of workers in the city of Matamoros, which is along a center of maquiladora production, low-wage export production to the U.S. that happened in 2019. It was sparked by an increase in the national minimum wage. Workers rose up and demanded that they get the increases that are actually in their collective bargaining agreements, which have never been enforced. With Susana's leadership, they created an independent union, and they won. Amazingly, they won these wage increases. What they weren't able to win in about 45 factories that were involved in this was independent democratic union representation. Not because SNITIS didn't try, but because the system is stacked against them. And this is the core of what we're talking about with the problems with the old NAFTA that Lori referred to, and that a lot of people in this audience know a lot about. And it's pretty straightforward. The workers don't get to see their collective bargaining agreement. They don't get to elect their union leaders. They don't get to engage in what we would consider to be, democratic collective bargaining. Anyone who steps out of line is fired, or worse, beaten up, shot, disappeared. Many documented cases that are unresolved, throughout Mexico. And this system has been in place for a long time, over 50 years. And the goal of the USMCA, or our goal in the context of the USMCA, was to bring about real changes to that system. And that included both the mechanisms that are in the treaty itself, the rapid response and other provisions, and significant changes in that Mexico committed to make in its labor law over a 4-year period. We're now 2 years into that 4-year period, and there's certainly a basis to assess, how well they're doing, and there are a lot of concerns about how they're doing on that implementation. I think. Do you want me to say more, Lori, or I think that really kind of frames it? I don't want to, I think Susana should tell the story of what's actually going on right now with the case. Just that, we worked, this case was filed jointly by the AFL-CIO, Service Employees International Union, Public Citizen, and SNITIS. So you have several of the actual litigants on the call here. And we see this really as a critical test, along with the case that USTR is now self-initiated on General Motors, which we could come back to. Also a very interesting situation. But everyone in Mexico is looking at these cases to see, essentially, is this for real? is Mexico actually going to do any of the things that it committed to do? Because there is a long history in Mexico of governments promising change and not delivering change. And then if they don't, is the U.S. actually going to take any substantive action that would dissuade employers, corrupt protection unions, government officials from acting the way they have been acting for the last 5 decades? So I'll stop there, and then we come back in questions.
Thank you very much, Ben. We will come back to you with a little after Susana for a little bit about that about the GM case. But it is now my high honor to introduce Susana Prieto Terrazas. She is an amazing champion of workers in the maquiladora sector in Tamaulipas and in Juarez. She is a relentless lawyer and brave leader. Many people on this listening here today helped elevate her cause in the United States when she was politically imprisoned under trumped up charges related to her advocacy for working people. She is somebody who is in the middle of what it will mean on the ground if these new labor rules do and do not work, and what it can translate to for workers in Mexico having better wages, a better life, better conditions, or she's going to be at the front line of being able to let us know the change is not real. So it is my honor to be able to introduce Susana Prieto. Susana, please.
Lo siento, estaba buscando mi micrófono. Muy buenos días, gracias a todos por la invitación a este panel. Realmente para mí es un gusto compartir con todos ustedes y sobre todo a nombre de los trabajadores mexicanos y especialmente de los trabajadores de Tridonex, de Tamaulipas y Ciudad Juárez, con los que hemos tenido tanto contacto precisamente para saber, como ha dicho ahora Lori, si realmente está funcionando o no este tratado o nuevo tratado de libre comercio, ahora llamado por nosotros el TEMEC, y fundamentalmente si está trabajando el apartado 23, porque en lo que interesa en este panel es, por supuesto, una cuestión de carácter laboral. ¿Existe o no libertad y democratización sindical en México, atendiendo a que el TEMEC constituye, junto con la Constitución Política de los Estados Unidos Mexicanos, la ley suprema de mi nación, de México? Y nos encontramos con que no. Nos encontramos con que el panorama que se vende hacia el exterior, tanto por parte de las empresas como por los sindicatos blancos enquistados en un sistema político que pues ya venimos arrastrando desde el siglo pasado, podemos decir ahora, pues no está funcionando, precisamente porque los sindicatos surgen en México como parte del partido político, el Partido Revolucionario Institucional. Posteriormente, en la alternancia en el poder, también el Partido Acción Nacional se ve beneficiado por estos y desaparecen, por ejemplo, al sindicato de Luz y Fuerza y a Luz y Fuerza completo, porque les estorbaba en un momento dado para los intereses de gobierno. No funciona el TEMEC, no funciona porque no solo por la corrupción de los líderes charros sindicales, sino porque hay corrupción de algo que yo he venido denunciando desde el año 2015 y que parece ser que hizo eco o detonó con la privación ilegal de mi libertad, porque al hacer pública la situación que acontece en México, pues entonces me convertí en el enemigo público número 1 de los dueños del dinero. Y los dueños del dinero, pues son los empresarios, y en este caso en el norte del país, pues yo ataco fundamentalmente a la inversión extranjera, a la inversión transnacional o a las maquiladoras. Las maquiladoras que desafortunadamente para nosotros se han mimetizado en la corrupción que existe en el país y que yo he declarado públicamente que no existe sindicato corrupto sin empresa corrupta, porque los trabajadores del país no tienen educación suficiente respecto de una lucha sindical, solamente obedecen las indicaciones de sus departamentos de recursos humanos y si no las obedecen para pertenecer a tal o cual sindicato, inmediatamente son despedidos y además boletinados, porque en lugares como Matamoros, Tamaulipas, la CTM tiene el control hasta del aire que respiramos. Cualquier trabajador de industria, de servicio, de comercio o de cualquier área está controlado por la CTM. Entonces, si tú no haces lo que una empresa te indica, avalada, sostenida y soportada por su sindicato, que es sostenido económicamente con las cuotas por sus trabajadores y que lejos de buscar, como tú lo decías, mejores salarios y condiciones de vida para sus trabajadores, se han constituido en el brazo derecho de los departamentos de recursos humanos de las empresas, pues entonces nosotros vemos que esto no funciona. ¿Por qué Matamoros? Porque esto estalla en Matamoros, porque Matamoros tiene los contratos colectivos de trabajo más impresionantes que yo he leído jamás a lo largo y ancho de la República Mexicana. Porque hubo un líder hace más de 30 años, Agapito González, que logró con lucha de los obreros y con concientización de los mismos que se incorporara a los contratos colectivos de trabajo de una cláusula donde los trabajadores debían laborar una semana inglesa de 40 horas, aunque bueno, también es americana, una semana de 40 horas y no más con un pago de 56. Y además de eso, los trabajadores, como el pretexto de la industria maquiladora, ha sido desde finales de 1960 que se estableció en mi país, que era culpa del gobierno, responsabilidad del gobierno mexicano que no se aumentaran los salarios, porque el gobierno no lo permitía, porque el gobierno establecía el salario mínimo y con esta charrería mantuvieron medio pues conformes a los trabajadores o resignados, porque yo a los trabajadores mexicanos les llamaría resignados a su suerte, resignados a vivir con salarios precarios, a que sus hijos no tengan oportunidades de salir de la pobreza, ni de ir a estudiar a la universidad, ni absolutamente nada. Bueno, pues resulta que este líder sindical llamado Agapito González, adelantado a su tiempo, dijo, entonces en México solo es obligatorio aumentar cada año el salario mínimo. Pero en México hace 30 años que nadie gana el salario mínimo, ni en la maquila, ni fuera de la maquila. Es algo irreal, es una utopía. No la pueden comparar con Estados Unidos ni con Canadá. Esa es una de las desventajas que nosotros tenemos. Porque cuando ustedes hablan de salario mínimo en sus países, es un salario obligado para todo el mundo. Aquí no, porque aquí simple y sencillamente no existe el salario mínimo. Por eso cuando el señor Andrés Manuel López Obrador llega a la presidencia de la República y a partir del 1 de enero duplica el salario mínimo, no se ve reflejado en ninguna parte porque eran muy pocos los trabajadores que en el país ganaban realmente el mínimo. ¿Por qué están enojados los empresarios? Pues porque ahora sí va aumentando. Desde que llegó Andrés Manuel López Obrador a la presidencia, también debemos decirlo, se dirá lo bueno y también tendrá que decirse lo malo. Si seguimos tratando de que nuestros gobiernos traten a los trabajadores con mentiras, nunca vamos a progresar. Se ha aumentado el salario en 2 años 146%. El salario mínimo, lo que no había pasado en la historia de los últimos 35 años en México, pero ha resultado insuficiente por la irrealidad del salario mínimo. Nadie vivía cuando llegó el presidente de la República con 88 pesos diarios por una jornada de 10 o 12 horas diarias. Vivían con 120 o 125, pero la obligación de aumentar cada año es solo para los que ganaban 88.36 y casi no había trabajadores de estos en la República Mexicana. La única salvación que tiene la clase trabajadora es el sindicalismo, pero el sindicalismo en México apesta, huele mal, provoca vómito. Al igual que hablar de políticos, los trabajadores se alejan y salen corriendo porque son el símbolo de todo lo peor que puede haber en el país. Lo mismo pasa cuando hablan de sindicatos. Ya cuando tratamos de hablar del Sindicato Nacional Independiente de Trabajadores de Industrias y Servicios, Movimiento 2032, tenemos reacciones de trabajadores que dicen todos los sindicatos son iguales de corruptos, son una bola de rateros, sirven al patrón, solamente nos quitan nuestro dinero en cuotas sindicales, pero no tenemos ningún beneficio de ellos. Ellos obtienen beneficios políticos y además se hacen multimillonarios, mientras mi salario solo decrece, mientras mis condiciones de vida cada vez son peores. Bajo estas condiciones, en términos generales, y para no aburrirlos, porque ustedes son expertos y lo saben perfectamente lo que pasa en el país, a cuentagotas, precisamente en enero del 2019, quisieron las empresas robar nuevamente el bono único anual a los trabajadores en Matamoros y ahí surge el Movimiento 2032. Una vez que se logra el aumento salarial y que se logra el pago del bono, yo no puedo encontrar una palabra para decirles cómo estaban los empresarios, pero es algo más que endiablados, como poseídos en contra de mi persona. Dijeron que me había mandado Donald Trump a desestabilizar el gobierno del señor Andrés Manuel López Obrador. Después hubo, y lo tenemos en todos los periódicos, hubo quienes dijeron que no, que era Andrés Manuel López Obrador quien me había enviado a Tamaulipas a desestabilizar el gobierno de Francisco Javier García Cabeza de Vaca. Bueno, no dijeron que me mandó jamás el grupo terrorista porque dijo ya era demasiado, o porque los que escribían sobre el movimiento 2032 en Tamaulipas no sabían quién era jamás. Pero nada más les faltó decir eso de mí. Cuando tú pretendes defender derechos laborales en México, simplemente terminas en la cárcel o muerto. Y es muy importante que el mundo sepa esto. Si soy enemigo número uno es por la visibilidad que he hecho a nivel nacional e internacional de la precariedad de las relaciones obrero-patronales. No solo las nacionales en México, sino las que provienen fundamentalmente de los extranjeros. Ustedes por años escucharon a la industria maquiladora estadounidense decir que ellos vinieron a quitarnos el hambre, que gracias a ellos los mexicanos comían, que el desarrollo de nuestro país era gracias a la inversión de los estadounidenses, que ellos pagaban mucho más dinero de lo que era el salario mínimo, que las prestaciones de ellos eran incomparables. No me atrevería a decir que a finales de los 60 no lo eran, pero ¿a cuánto tiempo estamos de distancia? Estamos hablando de más de 50 años de diferencia, y ellos siguieron esta regla de al lugar que fueres, haréis lo que vieres. Y tenemos a la industria no solo norteamericana, sino china, taiwanesa, alemana, francesa, involucrada en la corrupción con los sindicatos blancos de mi país para precarizar las relaciones obrero-patronales, empezando por los salarios y continuando por todas las condiciones de vida. No se nos ha permitido ninguna votación libre. Los gobiernos, que esto es algo con lo que cierro, el gobierno mexicano con la reforma que hizo la Ley Federal del Trabajo para poder adecuarla al apartado 23 del TEMEC, en letra muerta. Nunca contemplaron o sí lo contemplaron. Yo no sabría, porque a veces el gobierno es tan bien intencionado y a lo mejor la malintencionada soy yo. Pero fíjese usted que los estados del norte del país serán los últimos a los que se aplique la reforma laboral, por allá por el 2023 o 2024, que el sexenio del actual presidente de la República vaya terminando y sepa Dios en qué problemas nos van a meter para entonces, y si venga otro nuevo presidente y entonces diga, que va de retro satán, el señor está conmigo, y otra vez los fielders para volver a empezar y tener una ley arcaica surgida desde el movimiento revolucionario de 1917. No es posible que continuemos así, es necesario activar el mecanismo que contempla como una arma legal, que no es política ni es personal en contra ni del presidente de los Estados Unidos ni del presidente de México, porque a lo mejor ni saben el lío que traemos por aquí, el señor Ben, Public Citizen, los sindicatos americanos, el SNITIS, queriendo que se aplique. Este mecanismo es un recurso legal que está contemplado en un tratado internacional de aplicabilidad obligatoria para Canadá, Estados Unidos y México. Y México no está cumpliendo con la libertad y democratización sindical. No estoy diciendo que haya mala fe en esto, pero estamos casi a 4,000 kilómetros de distancia del centro del país y tenemos un gobierno eminentemente centralista que tal vez no se da cuenta lo que pasa en el norte del país. Es urgente que el gobierno federal no siga diciendo que todo es cosa de Tamaulipas o de Chihuahua, o del gobernador Cabeza de Vaca en Tamaulipas o del gobernador Javier Corral en Chihuahua. Es necesario mover a nuestros gobiernos para que todo esto resulte en un beneficio para la clase trabajadora de la ciudad y del campo. Que si me demanda Estados Unidos porque no cumplo el TMEC en las maquilas, dijo el presidente de México, pues demando a Estados Unidos porque no se respetan los derechos de los trabajadores campesinos. ¡Bravo, señor presidente! Todos los que estamos unidos aquí, lo único que pretendemos es que se respeten los derechos de los trabajadores, que haya mejores condiciones de vida partiendo por los salarios y las prestaciones adicionales a las mínimas que tienen establecidas en los 3 países actualmente. Si eso logramos sería muy bueno. Debemos, como experta se los digo, quitar el control a los gobernadores de las 32 entidades federativas o estados en México de las juntas de conciliación y arbitraje ya, si queremos que la libertad y democratización sindical funcione, porque no puede el presidente de la República estarnos diciendo, oh, esa es cosa de Tamaulipas o de Chihuahua, porque él, como presidente de México, firmó un tratado internacional que obliga a cumplir el TMEC a las 32 entidades federativas y que si las empresas transnacionales haciendo actos de corrupción no lo quieren cumplir, pues entonces también el presidente Biden tendrá que hacer las regulaciones o las reformas que sean necesarias al TMEC para que realmente funcione. ¿O para qué vamos a seguir teniendo tratados internacionales que no se van a aplicar? Más leyes siendo letra muerta, nadie quiere, no en México, en ningún país del mundo.
Susana, thank you very, very much. And in the Q&A, we can hear more from Ben and from Susana, and also my colleague Danielle, who helped with the brief on the Tridenex case, about the Tridenex case, the rapid response case, and the GM rapid response case. But, and we will hear more about the issue Susana is describing about how in the border states and places like Tamaulipas and Chihuahua, the workers in Juarez and Matamoros, who Susana has represented right now, don't have access to any court system, any labor system different from what it was like before the revised NAFTA and what problem that is. However, before we get to that, it is my honor to introduce Rachel Micah-Jones. She is an attorney and the founder and executive director of the Center for Migrants' Rights. It is a binational, transnational migrant rights organization that is based in Mexico and the United States. And her organization has petitioned the Mexican government to ask the Mexican government to file on behalf of several Mexican nationals who are working in the US to file a case. They're petitioning Mexico to file a case under NAFTA's state-to-state enforcement. There's several different kinds of enforcement of the revised NAFTA of the USMCA. So Rachel's going to tell us about that case. And then there's another case that the Mexican government has filed, which she may or may not mention, that is a similar state-to-state case that also has to do about the treatment by the US of Mexican workers working here. Rachel, please.
Great. Thank you so much. And thank you so much for having me. We all know that under NAFTA, labor was barely an afterthought. And at CDM, we had brought 2 complaints under NAFTA's labor side accord. And what we found essentially was that the agreement was basically toothless. It failed to provide sufficient remedy for workers and the migrant workers we represented in those cases. So when the renegotiation of NAFTA was announced in 2017, CDM mobilized with migrant workers and our allies to win enforceable protections under the agreement. Our efforts and the efforts of allies paid off. The USMCA includes an enforceable labor chapter, Chapter 23 of the agreement explicitly mentions protections for migrant workers and women. And under this agreement, labor violations can be adjudicated at the same level as other trade disputes. So on paper, I think the USMCA shows promise. Its dispute resolution mechanism could be a powerful tool to advance justice with migrant workers. And so now CDM is supporting migrant worker women in testing the potential of the agreement. When we look around at job ads in Mexico, we see things like men only 18 to 35. These are job ads for workers being recruited to work in the United States. And seeing a job posting with those words, it's really startling at this point. It's actually shocking. And even more than a year into this world-changing pandemic that has pushed millions out of paid work, US employers continue to discriminate against women, posting ads like that one. To evade legal consequences, US businesses discriminate in Mexico, hiring men to work in the US with temporary H-2 guest worker visas. And we just saw this week that the US government announced the expansion of the guest worker programs. And so this is an area where there's lots of movement on the policy front. The petitioners in our case, Maritza and Adarelli, both faced gender-based discrimination. Adarelli was recruited to work in the US in protein processing. Specifically, she worked in crawfish and crab. And she has years been denied access to H-2A jobs or higher paying H-2B jobs. Now, the H-2A and H-2B are visas for temporary work in the United States. Maritza was recruited to work in the US as a farm worker with an H-2A visa, where she was sexually harassed by her employer and never received justice. Their cases are not isolated incidents, but rather representative of the deficiencies in the guest worker program and the US's failure to enforce its labor laws and promote standards. At CDM, we hear stories like Maritza's and Adarelli's every single day. The rampant discrimination is backed by data. In 2018, for example, only 3% of the H-2A visa recipients were women. And as part of our complaint, we submitted disparate impact analysis that confirms the widespread discrimination in the programs. US employers and recruiters discriminate, and in the limited circumstances where they do hire women, they channel them into lower paying jobs. Sexual harassment is not uncommon, putting women in impossible situations to support or to suffer these conditions, poor conditions, or to leave and potentially face blacklisting and retaliation. And there are a ton of barriers for these women. The US government's policies deny them access to federally funded legal services. The terms of their visas require them to return home so they cannot pursue their cases. The appropriations riders prevent Department of Labor from enforcing some of their protections. And there are a whole host of other barriers that deny access to justice to these workers. And the imbalance of power is directly embedded into the programs and results in systemic abuse from the moment of recruitment. For decades, the lack of government oversight has allowed employers and recruiters to discriminate against women with impunity. The US government has essentially delegated its responsibility to set labor standards to employers, granting them the ability to choose who has access to job opportunities in the United States, who can come to the United States and who can't. And we all know that who is receiving these visas are people with certain characteristics, men between the ages of 18 and 35 years old. So we worked with Maritza and Nadarelli and members of our Migrant Defense Committee and a binational coalition of dozens of organizations, including progressive labor unions like the United Food and Commercial Workers in the US, the airline pilots, the teachers, laborers in Mexico, like the farm workers and domestic workers, and gender equity and human rights organizations from both countries. And on March 23rd, we submitted the complaint. And we heard, immediately after that the complaint had been received. And by March 31st, the Mexican government did notify us that the petition had met all of the requirements under Article 23 of the USMCA, and it had been admitted for review. In that time, we had conversations with representatives from both governments, and we raised the issues that women in these industries were facing. So we're talking here about agriculture and protein processing. And in those conversations, we understood that the Mexican government was using its consular network to then investigate more and to see what the abuses were in those industries for workers in farm work and protein processing. And so we were pretty pleased to see the letter from the Mexican government in May, asking for consultations under Article 23 of the agreement, asking for cooperative dialogue under Article 23. Because it really aligns with our petition and the issues faced by workers in those industries. And so we're pretty optimistic about at least the attention that this petition is getting and the quicker timeline, that of action in this circumstance, and hopeful that there'll be at least a little more attention to these complaints than there were under the NAFTA. Thank you.
Thank you very much for that overview. And again, folks who want to ask questions, get ready, use the Q&A function, and we will shift to the Q&A function and the Q&As right after we hear from our last presenter, and that is Daniel Rangel. He is the Research Director of Public Citizens Global Trade Watch. He was already hatched a lawyer and working in trade law after some work with the government in Colombia on trade issues when he came to the US to get an LLM at Georgetown and also got an economics degree at Sciences Po in Paris. And we are very honored to have him as our research director at Global Trade Watch. Among the excellent work that Daniel has conducted is an analysis that is now being published today as a new report that describes the process of implementation of the new labor institutions in Mexico that are required by NAFTA and by Mexico's reform labor law. And the findings are quite stark. It points out a large shortcoming that you have heard from both Ben and Susana, which is the institutional absence of change to date in the places where it's most needed. And we have some recommendations in this report that Daniel has authored about how to fix that. Daniel Rangel, please.
Thank you, Lori. Let me please thank you for all your thoughtful comments throughout the process of drafting this report, and I think that only made them better. I'm gonna share my screen so that people can see a little bit of the findings that we have. Let me know if you can see my slides. Okay, I think we should be good. So, Susana and Ben already mentioned it, but we want to underscore the reason why we decided to do this report is that last year, during a webinar very similar to this one, Susana gave an early warning about the uncertainty over the precise moment when the new labor courts will be operational in North Mexico. She said it again today, and the fact is that despite the fact that there has been a lot of progress in certain places with the implementation of the labor reform, what's going to happen with the states in the north border of Mexico is very uncertain. And in order to understand the importance of this of the idea of the labor reform and how the new labor institutions play a role within the overhaul of labor laws and institutions in Mexico. It's important to take into account that this was a commitment made by Mexico during the TPP negotiations. And this led eventually to Mexico reforming its own constitution in 2017. However, the reform was never materialized in federal law until there was a renegotiation of NAFTA in 2019 and President López Obrador was elected. So in 2019, there was the reform of the labor laws, in which there are two parts that are very important for our purposes. First, new guarantees and rights for workers, but on the other side, the labor institutions, courts, and conciliation centers, where workers could actually claim their rights and could actually fight for the enhancement of their wages and working conditions. The problem here is that, well, it's not the problem, it's something that was understandable. So Mexico decided, okay, we're gonna implement this reform in a staged way. And they decided to divide the states in 3 groups and then assign a deadline by which each of these groups will have to have the new institution, the labor courts, operational. And it's important to take into account also, and this is a little bit into the weeds, but bear with me, that there are courts that decide over federal jurisdiction and state jurisdiction. So the court that decides over federal jurisdiction, and these are basically key sectors of the economy. So automotives, mining, metals, these kind of sectors, they have a court that is located in Mexico City that is already functioning, and that what the government decided when it did determine this schedule was that this court would only know cases that arise from states where the local courts are already in place. This is something that is important. We will discuss it a little bit more later on. And the other element that is important to take into account is that once a case is started under the old system, it will remain in the old system until it's finished. So the old local boards these boards are problematic because they have been colluding with employers and with protection unions for decades now. They will keep functioning many years after the implementation of the new courts in each of the states of Mexico. So, as is pretty obvious with this map, we can see that the third stage where the new courts are going to be implemented only into 2022, the North is basically backloaded in that later stage. And this is something that is rather striking if we consider that the north of Mexico and other states are also in third stage. They accumulate basically half of the manufacturing output of Mexico. This graph shows how, while the third state, the phase 3 states have around 45% of the manufacturing output, those states in phase 1 that are the only ones that have currently the new labor courts have around 20% of the manufacturing output. And this wouldn't be a problem if we don't see this clear correlation between manufacturing GDP and the frequency of labor conflicts in Mexico. This is the reason why we found very striking that the government decided to leave last those states that had the highest industrial activity. Because when we look at the states, not individually, but we look at them as a group, according to the phase in which they are, we can see that phase 3 states have almost twice as much labor conflicts than phase 2 states. And they have 3.7 times more conflicts than phase 1 states. This is using data from 2016 and 2018. This is government data that is most updated that we found right now from INEGI, that is the Statistical Bureau of Mexico. And this is even more problematic if we see what happens with strikes. The great majority of strikes in the country happen in the states that have been left last. And those are the states in the north and also a couple of other states. So while there is 25.7 states new strikes per year. In these states, in phase 2 states is 4.3, and in phase 1 is only 1.5 new strikes per year. So this makes it very clear that the states that needed most direly the new institutions are those that are not going to see them for an additional year. And that's even more problematic if we see that, as Susana mentioned, those states in the north of Mexico are those that are most closely linked to the international economy. They receive almost half of the FDI that gets into the country, and they export half of the products that go abroad. And this is something that is also important to take into consideration in the context of the USMCA, because if workers in the north of Mexico do not have local fora where they could review their cases and where they could actually claim for the enhancement of their working conditions, then they're going to reach out to international partners and they're going to make use of the USMCA tools like the rapid response mechanism. And this is something that increases liability for Mexico. So it's in Mexico's best interest to give workers the right forum to redress their claims in Mexico. So what are the policy recommendations that we include in the report? And they were also mentioned by Susana. We are just pointing very specifically to what could the government do to enhance the situation. And it's first, and this is something that I forgot to mention initially, and it was that this schedule that I was mentioning before was reformed several times over the past 2 years. So the states that were part of phase 1, phase 2, and phase 3 were changed constantly, with the only constant that was the phase 3 states were those that represent half of the manufacturing output. But other than that, they were changed, and they were changed because of the pandemic, and that's understandable. But also that introduced a lot of uncertainty on when would the new institutions be in place in different places. So what we're saying now is you can change it again, and you can include in phase 2, where the new courts should be operational in October of this year. And you can include Tamaulipas, Chihuahua, and other states with high industrial activity and with a lot of labor conflictivity. And that will be something that would allow workers in those states to have new institutions to redress their claims pretty much in a couple of months. And the other solution, which is important, that I was mentioning with the difference between local jurisdiction and federal jurisdiction, is that the Federal Labor Court for Collective Matters is already functioning and is receiving cases. It has handled 73 cases by now. And this court has competence over all of the cases that are arising in these key industries, metals, automotive, auto parts, in the entire country. So it will be easy for the judiciary of Mexico to amend its regulation to say every case in every state of the country that is related to these sectors has to go to the new institution. And this is something that could be done and is in the best interest of Mexico and workers across North America, because basically the whole idea of the USMCA is to provide a forum, is to provide the opportunities to workers to have forums and to have rights so that they can increase their wages and they have dignified working conditions. And this is something that could be done fairly easily so that we can achieve that objective.
Daniel, thank you very much. So the report can be found at tradewatch.org. And again, the findings: the states in Mexico that most desperately need the new labor system are the last where workers will have access to real justice. But in that scheduling, there is flexibility. And so the recommendation of this report is, number one, the Mexican government use the discretion it has to allow workers to go to the already functioning federal new reform jurisdiction for auto and other sectors, which right now is being restricted to only workers in states that have the new system, where the new system is not in place where workers need it most. And that, number two, the phase-in be altered to front load more of the states where there are the most problems. given, as the report documents, the old institutions, the leaders of them think they'll be around for years with backlogs of thousands of cases that they'll be deciding. Thank you to all of our amazing panelists, to all of you for sticking in there. Martin Del Campo, yes, there will be materials available, including the report that Daniel was summarizing at tradewatch.org. A video of this and a transcript of this excellent webinar will also be available at tradewatch.org and perhaps at our partner groups' websites as well. A final thank you so much to everyone, our participants, for their words of wisdom, for all of the hard work to make a reality, better workers' conditions and wages in North America. And to the audience, thank you very much. Thank you all, and good afternoon.
Rethinking Trade is produced by Public Citizens Global Trade Watch. To learn more, you can visit rethinktrade.org. You can also visit tradewatch.org. Stay tuned for more, and thank you for listening.